I'd like to now invite our second speaker, Richard, onto the stage to deliver Isa's paper for this session.
Good morning once again. I'm back on the stage. This time, you just need to pretend that I'm Aziz Ibrahim, except I'm shorter. Paul, thank you. Excellent talk. I felt I was back in university and learning sports arbitration in a tutorial. In fact, it was a lecture. Thank you very much. So I'll do the easy thing, like what most lawyers will do. I adopt and adapt entirely what Paul has said. That will kind of speed things up. What we have done is that, let me try to figure this out. Hardly use this. All right, okay, I found it. So what I intend to do today for the next 50 minutes or so, because I would like to have a Q&A, and I think that's a little bit more important. I'll zoom into Malaysian areas. There are about 7 slides there. There are 27 slides we have, but 6 or 7 slides are about Malaysian law, particularly the Sports Development Act. And that's where you may have heard Imran already mention a little bit about that act, and we will zoom into that, and then we will conclude about what we can do. I'll take my place, and then Peter Ling will moderate and do a Q&A. So what I'll do is that very much like what Paul has said, Malaysia is definitely heading towards an area where for sports dispute we will be utilizing CAS. You have heard from Paul, how do we activate CAS, the Rule 27, etc., etc. Basically, if your contract has a arbitration clause in sports, you will be referring your matter to CAS in time, and I'm looking forward to serve on MSAT, the Malaysian Sports Arbitration Tribunal. Once that goes up and ready, all of us can learn and eventually serve on that board or at that tribunal. So what I want to first show here is this one. This is the sports-related disputes in Malaysian context. The SDA 1997 is the Act of Parliament pertaining to Malaysian sports. It unfortunately does not define the meaning of the word or the phrase sports-related dispute. It does has some element of procedure, and you will see that in this procedure, it will include an appeal to the minister, which is rather odd if you ask me. Perhaps in 1997, that was the vision, and you must understand, in 97, we were 1 year away from hosting the biggest games in Malaysia, the Commonwealth Games. And I believe at the time when we were going through this Act of Parliament, I was still in law school at the time in 97, so I really can't understand the reason and logic behind that. But I believe at the time, the idea was to try to make sports more uniform, more organized, and placing the minister as the fundamental and final person of appeal made sense at the time. And so this is the Act of Parliament which is involved. These are 2 cases which I want to show to you. The case involving, some of you from Kedah will know him as Karim Pin, a very good footballer in his time. Unfortunately, he was arrested and detained on suspicion of match fixing. And Dollah Saleh, which is our current national footballer, one of the best left-footers we have in the Malaysian football game. In both these cases, what was important and interesting is that the disputes were pertaining to the contracts, their games, what their obligations were in their sport, in their contract with their relevant state body. Kedah, for example, with Karim Pin, Karim wanted to leave Kedah, but he could not. In both cases, Dollah and Karim took the cases to court eventually. They had an internal tribunal heard within the organization of either Kedah FA or Johor FA, and eventually both cases went to court. And you can see that it looked like the court didn't really understand how the football federation worked. And in both cases, like this one, if you look at this, in Karim Pin's case, it says the Supreme Court held that there was no provision in the Constitution which allows the respondent to resign. And those who are in football will know footballers don't resign. They either play out the contract, finish the contract and leave on Bosman, or they get transferred where the selling club will gain a substantial transfer fee. So for a court to use that phrase, I thought perhaps the court may not really appreciate and embrace what football transfers is about. So these are just examples of the issues that we face in Malaysia. These are the rest of the stats here are pertaining to the general mechanism of sports dispute resolution, which Paul has covered. History of CAS, not only Paul, I think Tengku Imran has also mentioned that. This is the Malaysian context, as you can see. The second point, in Malaysia, the Ministry of Youth and Sport is responsible to ensure the welfare of the sports community. The governing sports bodies has its own structure and have its own bylaws and constitutions to be recognized by the international federations and OCM. So, in Malaysia, every sports organization or sports association have their own internal rules, which unfortunately will result in every single association having their own internal dispute resolution. So, a player of Wushu who didn't turn up for training may be fined for 5 months of wages, whereas a player for a football team may be sacked for also missing training. So there's this issue of inconsistent decisions by the sports association. Section 8 of the SDA recognized OCM as the National Olympic Committee of Malaysia. This is how our country's sport is structured. OCM is the paramount and pinnacle of body of our sports organization. They are the tip of the spear in anything relating to sports in Malaysia. And you will see in Article 5.13 of the Constitution, it gives jurisdiction to OCM to do all things necessary with regards to settling dispute. So you've heard earlier, Tunku Imran mentioned where Dato' Roy Rajasingham, in his days in OCM, set up a particular dispute resolution body, and now they're trying to do the same thing. So this is the power that they get the force from to carry out the new MSAT. This is the governing laws again. We're just going through CAS. So this is the list of cases which refers to us Malaysians. So we got the SDA, our Arbitration Act, the Constitution of OCM. I would strongly recommend any of you who are interested in sports law, you have to learn the Constitution of OCM. And of course, for purposes of advising your clients, you will need to know the Constitution and bylaws of sports bodies in Malaysia. So for example, golf have a very unique set of constitution. So you need to understand how golf works in Malaysia, particularly the golf associations. So this is the current, what we have, we deciphered from the procedures for sports dispute resolution in Malaysia. Basically, it's first an internal hearing, as I said earlier. So if a local football player refuse to listen to the instructions of a coach on a pitch, and the football club in Malaysia will be Football State Association, initiate an investigation and conduct an internal tribunal. This is how it works. So the player will face the consequences of their conduct, and eventually it will be referred to the minister, as I said earlier. This is pursuant to the Sports Development Act. It may also be referred to OCM. This is the current rough, very, very summarized structure of how it is now in Malaysia. Section 23 and 24, very important sections for us to understand for sports dispute resolution. In Section 23, it provides that disputes arising among members of the committee to be resolved in accordance to internal procedures. So that's my personal view is that the SDA requires some amendments, perhaps some tweaking. Even in my discussions, my personal discussions with the former sports commissioner, I get the feeling that even the sports commissioner wished to amend the SDA. And you can see, if we are going to have a uniform sports tribunal in Malaysia, this has to be tweaked. And Section 24 of the same Act provides that all decisions made pursuant to the above may be appealed to the minister. So eventually, at the end of the day, I must be blunt here, if the minister likes you as an athlete, you probably get away. You know, so if you are an extremely famous badminton player, you may just get away. You know, while we all love badminton, you know, it's one of the best sports. We'll probably win our first gold medal from that game. But if you've done something illegal, you've done something illegal. That's my view. But that's the danger of that. We have a political appointee deciding what really is actually a sports issue. I must say something about sports. Sports dispute is a very unique area of dispute. It is a few area of disputes where passion and emotion gets involved. You go to a dispute resolution for sports, and you do not just listen to, as Paul just mentioned, you don't listen to earlier decisions. You're not bound by stare decisis or stare decisis. Some people pronounce it that way. There's no precedent for you to become. You just go to a hearing, submit your case, and sometimes you even argue it out purely on passion. And that is sports. So really, in my view, sports dispute resolution should be left to sports people, not government appointees. So OCM got it right. You know, getting MSET together with KLIAW, that's correct. To get people who really understand sports, to regulate sports, to understand sports. So these are what we have at the moment, and in my view, it should go. So this is the rough pictorial of how you activate this, section 23, 24, and this is the process that we have at the moment in Malaysia. I'll just fast forward because, like I said, I'd rather hear you than hear me. This is Cass, and yes, this case. So Paul have already discussed it. Miss Paxton's case, I hope I pronounce her name rightly. You know, we Malaysians, we can't get the the English names. In fact, she's not English. I think she's Swiss or German. She's German. She's German. Yeah. In this case, what is interesting is that, as Paul has mentioned, the German court has declared the Cass's decision not applicable. So there is a question mark on whether Cass still has a future. In my view, Cass is still the main supreme court for sports. Purely, as I said earlier, they really understand sports. I think what is important for Cass now is to look inwards instead of trying to accuse other people of not following Cass. I don't think they're doing that, but if they are, then they shouldn't. But I think Cass should look inwards and try to improve themselves. They've done it twice. They've improved themselves in the 90s, and they improved themselves earlier in this century, and they can do it again. And I think what is just important is to find a fair system to select the accurate arbitrator. Then they will lessen the issue of a question of impartiality. So this is the Paxton case, which I believe Benoit, you'll be discussing this case later in the afternoon. So I hope you stay on. This is a very, very interesting case to study. And we will need to understand the impact of this decision for sports arbitration. So for those of you who intend to practice sports law, this is your Wilmington against DPP. You need to understand this case. The KLIAW against Public Spoke Balls. We need to understand this case. So I'll end it here by saying that I hope when we start the Q&A, please pose as many interesting as possible questions to Paul. Make sure that you just ask Paul because I'm pretending to be Isa, but no, I'm just joking. I look forward to hear questions. The whole idea of having this conference is to hear from you, to get the delegates' point of view. We want to have a dialogue, not just a one-way traffic lecture. So I'm going to pass the mic back to the MC, who will invite the moderator, and I look forward to hear your questions in a short while. Thank you.
Thank you, Richard.